Testing, Judge microphone 7. Testing, Judge microphone 6. Testing, Judge microphone 5. Testing, Judge microphone 4. Testing, Judge microphone 3. Testing, Judge microphone 2. And testing, Judge microphone 1. Appellant mic. Appellant mic 1, check. Appellant microphone 2, check. Appellant microphone 2. Appellee mic 2. Testing appellee mic 2. And appellee mic 1? Yes, appellee mic 1. Here we go. Okay. court at Portland within the state of Maine may come forward to declare, and they shall be heard.
Good afternoon. You can be seated. The matter before the court is our docket number OJ 26-1 in the matter of a request for an opinion of the justices. I see counsel are present. We have been in communication ahead of time to talk about how time was going to be allocated, and I understand there's an agreement on that. Counsel who will be arguing, I would ask that you introduce yourselves for the record, stating the party that you are representing. Starting with, why don't we start with Mr. Brann?
Madam Chief Justice and Justices of the Supreme Judicial Court, Peter Brann for the State Senate President and the Speaker of the House. Everyone agrees that whether...
I'm going to ask that all counsel introduce themselves first. I'm sorry.
I was all ready to go.
I know. We'd like to know who's here. So that
Not a problem.
and luckily, that doesn't count against your time either. So.
Good afternoon, Your Honor. David Kallin for voters of Maine.
Thank you.
Good afternoon, Your Honor. Jonathan Bolton, Assistant Attorney General for the Attorney General.
Good afternoon, Your Honor. It's Tim Woodcock. I'm here for the Republican National Committee, the Republican caucus in the House, the Republican caucus in the Senate, and the Maine Republican Party.
Thank you. And as I indicated, we did receive briefs from other people as well, other parties as well, interested parties. But by agreement, these are the parties who will be heard orally here today. And with that, Attorney Brann, we would now be happy to hear your argument this afternoon.
Thank you. Everyone agrees that whether LD 1666 conforms with the plurality requirements of the Constitution presents a solemn question. So I'd like to use my opening remarks to address the merits. Applying the plain language of LD 1666 against the plain language and purpose of the plurality requirements, the justices should opine that it is constitutional. The answer to this question is not governed by the 2017 opinion. The opponents treat it as a precedent, citing it numerous times, but that is not true. The 2017 opinion says it is only the individual opinion of the justices, of the sitting justices at the time. It expressly states it's not binding precedent, and it is not even stare decisis. This is a different experience, and indeed, now that we have experience with the ranked choice voting statute, the unexamined assumptions of that opinion can be re-examined. And it has also, the ranked choice voting has twice produced plurality winners. And if that's the case, then it is constitutional. The standard here supports the constitutionality. The proponents, although we're listed as the appellants here, do not have the burden of proving this statute is constitutional. On the contrary, that lies exclusively with the opponents. We begin with a heavy presumption of constitutionality. The opponents must prove beyond a reasonable doubt that there is no set of circumstances where this statute is constitutional. Thus, the two examples that we identify in our papers where ranked choice voting produced a plurality but not a majority winner means the statute is constitutional. The LD 1666 explicitly provides that a successful candidate wins by a plurality, and the justices should take the legislature at its word. The plain language and purpose of the Constitution supports this conclusion. The Constitution requires only that there be a plurality of all of the votes returned under the Constitution. That's the language. The Constitution also gives expressly to the legislature the power to, quote, prescribe the manner in which the votes shall be received, counted, and the result of the election declared. You put those two together, we find this is constitutional. You can't add language to the Constitution. We apply the plain language. So there is no first plurality. There is no final plurality. There is no plurality system. And there is no first by the post, all of which are things that have been added by opponents in opposing this particular statute. But also, it's not just the language. We look at the purpose of this constitutional provision and look at the history of it. And the purpose was to avoid failed elections, number one, and secondly, to make sure that the elections were determined by the will of the people, not by some cabal, by somebody else. And so therefore, the purpose was to establish a winning threshold, not a method of counting the votes. And it would be the height of irony to treat it as anything other than that.
Is the ballot a vote, or is it an instruction to do some other things that will eventually turn it into a vote?
The ballot is the vote, which contains instructions on how to count it. And so that is the
So if
way
it's a
in which
vote and it says I vote for Jones, isn't that the end of the road?
No, it is a vote that my first preference is Jones. But if Jones is not available, then I'm interested in Smith.
So it wasn't really a vote for Jones, it was an instruction to the person who receives the document to say, oh, okay, Jones is out of the running here, so now your vote is for Smith.
It really is, the analogy which has appeared in some of the briefs, it's like going to the deli. I go there and I say, I'd like an egg salad sandwich, but if it's not available, I'll take a ham and cheese sandwich.
But the deli doesn't have constitutional rules. We're dealing with a very
Right.
consequential document here.
Absolutely. And the consequence here is that you look at the ballot in its entirety. Someone could say, I'm only going to vote for one person, or I'm going to vote and I have a contingent person I'm going to vote for.
But how do you deal with the fact that on that ballot, if we even follow what you're saying, the municipalities must receive the votes of all the qualified electors, sort, count, and declare them, and a list of the persons voted for shall be formed, and then it's reported on. And in fact, 21 MRSA Section 711 says, for elections determined by ranked choice voting, the municipality essentially shall report on the election return only the first choice votes cast. We've got constitutional provisions requiring the municipalities to essentially perform the work and simply report the results, and yet under ranked choice voting, they can't report the results. How can that comply with those provisions?
Well, in the same way in which, when those provisions were originally passed, that was before there were voting machines. So voting machines are allowed.
Well, that's by amendment of the Constitution.
That's true, but it also is that you're still able to declare, you're able to count them, you're able to do that, but you don't know who's going to win until you've counted. You can look at absentees until you looked at.
But it's by amendment of the Constitution, and clearly the Constitution could be amended to permit ranked choice voting, but that's not what's in front of us.
Correct. And the question is, does the statute allow for an election by a plurality? That is really the bottom line. It's not. It doesn't specify the method of doing it. You do collect the ballots. You do declare them in the same way, but you're not going to know
But
who
doesn't
wins.
it also, I guess I'm a little confused by that argument that the only issue is plurality. I mean, it also requires that the process comply with the other provisions, the other sentences, if you will, in Article 4, Part 1, Section 5, Article 4, Part 2, Sections 3 to 5, and Article 5, Part 1, Section 3. It's not just the word plurality, it's the whole process.
Well, we're focused, the briefs were all focused, at least initially, on
I
plurality.
understand they were. I'm raising a different question. I understand they
Fair
were.
enough. But here's why I think it is, that going down that different path is probably not the place to go today. And for one of the reasons, would be collateral consequences of trying to say, do we take a rigid, formalistic view of that sort, count, and declare? Because what it would do...
Is it a rigid, formalistic view to take the language as it is?
If the answer is those votes don't count unless you actually do that at the local level, that would disenfranchise deployed military, overseas voters, because those ballots
Which are also authorized by constitutional amendment.
Not the method of which they're counted. That's the whole point. If they're authorized to vote overseas, but the method in which they are doing that is still controlled by state law. And there is a risk of collateral consequences if we take an overly formalistic and rigid view.
Just looking, counsel, just looking at that language, though, it requires that the local election officials receive the votes receive the votes of the qualified electors, sort, count, and declare them the votes. What are what are the votes? It's not ballots, is it? What is vote here?
They're definitely sorting them. They're definitely telling
Sorting
them the ballots.
what?
The ballots.
But they have to count the votes.
And they do. They're able to give that because they give the numbers. The reason, if you think about what the purpose of that statute, of that part of the Constitution should be, it's to make sure that we know how many people voted in Wayne, the town of Wayne, how many, and what are the total numbers. And you also, they actually give out what are the preferences. So it tells you that. It doesn't tell you, it's not going to tell you who's going to win until you know the other results from other towns, from absentees, overseas ballots, recounts, et cetera, et cetera.
But it doesn't say count the number of voters. It says count the number of votes. So I'm asking you, what is the vote that they're supposed to count?
And coming back to the colloquy with Justice Meade, it is the ballot. It's telling you, in Wayne, there were this many ballots.
So you agree that they do not report the second choice or anything like that to the Secretary of State?
As my understanding of how it's currently formulated, is that they do not say, this is how it's going to work if we get to a second round.
Well, and the statute specifically says that they are to report only the first place vote.
But that still serves the purpose. If you think in terms of what's the point behind that constitutional provision? It's to make sure we know that there are not people stuffing the ballots. There's an ability of the public to monitor that process.
As the only member of the court who was on the 2017 decision, I'm trying to determine whether this is really something new or whether it's simply kind of a mirror image of what happened before. There's some different language here. We're calling the ranked choice ballot as an instruction rather than a vote, and referring to a ranking rather than a vote. Candidates are limited rather than removed from consideration. And it's a tabulation, not a count or a vote. Are those really substantive changes? Is this a whole new animal coming to us, or is there a reboot of what happened back in 2017?
I think the way in which I would characterize it is to make explicit what at least the proponents thought was implicit before, which was that the ballots are the vote expressing preferences. And then you go to the question of, does that give us a plurality winner? And as we point out in our brief, there are at least two examples where that's the case, which the 2017
Well,
justices
can I
didn't
go
have
back
available.
to something you said earlier, which is it's just preferences, and so what happens is the voter has the first round, and then you said, and if the first choice is, quote, not available, but that first choice was available the first time around.
Sure.
And if you looked at, and that person may have won the plurality at that first round. So not available, it really does, he's excluded from being able to vote for that person?
No, quite the contrary. In fact, our position is that it actually facilitates being able to do that.
But he can't, but he voted for somebody, that person got the plurality, and it doesn't matter.
No. We push
That's
back,
how it
I'm
results.
pushing back on the premise of that because that is the leader after the first tabulation. Because
The person who has the plurality of votes.
the implicit assumption there, which is what the LD 66 corrects, and what the experience shows and what the math shows, is that shows only what is the preferences at that point.
So he has more votes. He has more votes than anybody else, but that's not a plurality.
It's not a plurality unless you were able to add the word first plurality, or first by the post, or some other limiting language which does not appear in the plain language of the Constitution.
We don't have to add any language. It is a plurality in terms of what's been counted at that juncture. You can come up with rules to go beyond that, but you still have a plurality.
And we know who it is. I mean, and we all know who had a plurality on the first ballot.
But it's not a plurality if the counting process is not done. The reason, and so to your point, we might know who's ahead after the first quarter of a basketball game, but it doesn't tell us in anything where people count what the final score is. What you have to do is you say,
Unless the rule said if you're ahead at the end of the first quarter, you win.
which would be, and if the Constitution had language that referred to a first plurality or first by the post or something like that, then sure, that would be true. But that's the language, that's the magic language.
Doesn't the
that's missing.
Constitution just simply call for someone to have a plurality?
It says a plurality of all the votes. And so what it means is that you have to determine if that's true. And if this approach, which is the question is what does this approach provide? And what it does is it is the voters will express a preference. And when you get through the end of the counting process, you will know who it is who has the most votes. You don't know that in the beginning.
Counsel, in the limited, go ahead.
Thank you. I'm just still trying to understand this. I understand your argument that there's a difference between a preference and a vote. And I guess your textual support for that is LD 1666, is that right? It's the language of the statute?
Along with the language of the Constitution itself.
But where in the Constitution does it tell me that a ballot of this sort is a preference, not a vote? That's what I'm struggling with. Where are you getting that from the Constitution?
Well, the Constitution refers to a plurality of all the votes.
Right.
And the question is, if your ballot contains, your contingent possibilities, if you will, it tells you and along with instructions how to count it. Then the question is, does that produce a plurality winner? And so that's where the legislature was given the power, in Article 9, Section 12, to prescribe the manner in which,
But I guess going back to this, sort, count, and declare, doesn't that give us a clue as to what the Constitution might mean when it describes a vote? And wouldn't that trump any statutory definition of vote?
I think that I think that that elevates a level of formalism that may have made back in the 19th century when people put ballots in
Well,
piles.
it may be formal, but it's in the Constitution, isn't it?
But it still serves. I'll just finish that.
It was on before she asked her question.
Well, maybe I won't.
No, if she asked the question, you can answer.
Just kidding. But I think that's in there. But we look at it and we say, how does that actually apply in the 21st century? We don't say that the votes of deployed military don't count because the Secretary of State is the one doing it. We don't say that overseas ballots don't count. There's a little bit of play in the joints, given so we don't go to a completely literal formalism that then leads to some very adverse collateral consequences.
Thank you, counsel.
And give the balance of my time to Mr.
Good afternoon, may it please the justices.
And Attorney Kallin, since your green light is on right off the bat, I'm going to ask the question that really is the first question I probably should have asked but did not. We asked everybody to address whether this is an appropriate solemn occasion. Let me ask you this. In 1961, in an opinion of the justices, we indicated that it would not be a solemn occasion if the question is asking the court to overrule a prior decision. So why is this a solemn occasion, given that we've already essentially answered the question in 2017?
You've never answered the question on the legislature's authority. The legislature's asking you. In 2017, the legislature wasn't here asking you. There you had the executive asking about a law that had been passed by initiative and that had never been implemented, asking whether and how they could do
But isn't this a question essentially, we didn't like your answer in 2017, try again?
No, and here's the reason. Ranked choice voting is a better way of electing candidates because it identifies a candidate with the most popular support. It is good policy. And so what that means, it being good policy, the legislature has plenary authority to adopt that policy unless the people in adopting the Constitution said it's such bad policy that we're going to take it out of the legislature's hands and they can't do it. And here you have the legislature asking you about their own authority. You've never had that before. And there was a decision in 2017 that made an assumption about this and seemed to say it would be outside the
Do you agree that
legislature's
if the
authority.
text is clear in the Constitution, we don't look at policy, We don't look at anything else. The text is the text, and that's it.
So the text is the text, and the 2017 opinion did not rely on that text. It actually relied on this concept of a first plurality, which is not in the text. Remember, plurality is just the most of something, right? Plurality is not anti-majority. It's important to remember what the majority provisions were. That was a threshold that could cause a failed election, right? So if someone didn't get at least half the votes, the election failed and you did something else. So what the most votes means is it's not saying it's constitutionally suspect in Maine to get more than half the votes, or it's constitutionally suspect in Maine to have a system that identifies someone that has majority support, right? What it means is that there's not a threshold that causes a failed election where you do something else.
So where in the Constitution do you find support for the proposition that the legislature has specific authority in this situation? Is it Article 9, Section 12? Is that the linchpin of your argument?
No, I think we start from the separation of powers, and this court has been clear on many occasions that the legislature's power is not one of expressly given by the Constitution. It has plenary authority to legislate unless
it
expressly
conflicts,
limited.
unless it's expressly limited.
Exactly.
Correct.
And so what we find in the Constitution is that it doesn't expressly limit that. Remember, we have, for example, the Poliquin-Golden election, right? That's an election decided by votes. The person with the most of them took office. That was Jared Golden. He got the most votes, at least for federal purposes. So is there something in the Maine Constitution, in its text, that says Maine is narrower? When it says the most votes, it means something different. It means Bruce Poliquin got the most votes and Jared Golden got
Except that
something
the provisions about plurality and the method by which the votes must be counted at the municipal level do not apply to federal elections. These are only provisions that apply to the elections for representative and senator to the state legislature as well as governor. They don't apply. They never did apply to the election for the second congressional district.
That's very true. But if the question is the word vote in the concept of the most votes or the plurality of votes? Because remember, it was the most votes or the highest number first, and then it became plurality. Is that concept, is the term vote, did Maine, when it adopted that word, did it mean to limit its legislature more than every other jurisdiction that uses that?
It did seem to mean vote. I mean, if you read on in Section 5, as I was describing earlier, sort, count, and declare the votes, not the ballots, not the preferences, but the votes, with the number of votes for each person against that person's name, and then that has to be reported up to the Secretary of State.
Right.
It would seem to me that even though it may seem outdated, but the Constitution has a specific meaning for what vote is.
And it goes on to say that give no role, essentially, to the Secretary of State in tabulating anything other than simply reporting it out. So adding that to Justice Douglas's question.
If I could address the two.
Well, I think it's part of Justice Douglas's question.
Right. So I do think I want to address it first, accepting the premise, and then explain why I think the premise is wrong. And so if it were true that sort, count, and declare was supposed to be a way to narrow what the word vote meant, that's a very tangential way to do it, right? The Constitution, if it meant to limit the legislature, would have been much clearer than that we sort and count the votes locally. And it's not impossible to do, right? In single choice voting, what did that mean before we allowed voting machines and these other things? It means you took the ballots, you sorted them into piles, and you declared how many were in each pile, and the names that were on those ballots. You can do the same thing in ranked choice voting. You just have more piles. And if the question is, did the municipality do what it was supposed to do in the election under sort, count, and declare, that's a somewhat different issue. If the question is, as it is framed here, and as the legislature has asked about, do we have the authority? All these other jurisdictions that use the most votes wins. If they could do that but for sort, count, and declare, you'd still need to answer the question. The 2017 opinion didn't look at the sort, count, and declare. If the constitutional fix is just that you repeal sort, count, and declare and you leave like the most votes wins, the plurality provisions, because that would be the necessary outcome. If you determine that the only thing that limits votes to be something less than what Jared Golden got, something narrower, so that only Bruce Poliquin got the most votes, not the person that we put
Or
in
we
the
read it as a whole, which is what we always say we always do, and the provision regarding plurality is in the same in the same parts or sections as the provisions talking about sort, count, and declare. And don't we read it all as a whole? Then
So
each informs the other.
And reading the Constitution as a whole, I think you'd have to address pretty squarely that Article 9, Section 12 language.
And it gives the legislature the power under Article 9, Section 12, to by law divide the towns into voting districts for all state and national elections and prescribe the manner in which the votes shall be received, counted, and the result declared.
Right. So if
But
you
that
took
only can be to the extent not inconsistent with Articles Article 4 and Article 5.
Well, it's a later amendment, so it can change.
But it was
sort, count,
an
and declare.
amendment for a specific purpose.
Yeah.
But
And
if
the
that were the-
specific purpose
Right.
was to, as the title suggested, allow larger towns, those more than 4,000 inhabitants, to subdivide and create different districts for polling purposes.
But it uses the word vote. And so if it's really the case that sort, count, and declare meant that vote is something less than a ranked choice ballot, because Jared Golden got the most of something.
Well, there wasn't a great deal of ranked choice voting at the time they made the changes in the 19th century, correct?
Correct. And the reason we had majority voting is because they thought that popular support was a really important thing.
Well,
and that's what I mean by
let's get back to the purpose when the amendment was made. What you're saying is under ranked choice voting, the election isn't over after the first round, correct?
Yes.
Yes, okay.
The ballot.
So back then, the problem was they couldn't get a majority after the election was over. Nobody got a majority, and bad things happened. So they then decided, you know what? You don't need a majority anymore. Plurality will do it. The election will be over after you count them all up. And we don't need runoffs.
Exactly, and ranked choice voting does all of those things, because what they didn't say was if you do get a majority, it's a failed election and we want someone who got less support, right? And
I didn't follow that. Can you explain?
And so let me try to explain it. So ranked choice voting does not have a trigger for a failed election. That's what they removed, was the possibility, and ranked choice voting is not more than one election, right? People analogize it to, but when you ask about rounds, the Constitution doesn't talk about rounds. If the legislature were to pass a law saying we count towns alphabetically, and after the first round we declare who's got the first plurality of all the A towns, then the fact that we're supposed to declare a winner as a plurality winner, we wouldn't stop then.
Is ranked choice voting just recounts on steroids? Is this just a backdoor way to stack recounts when there's a close or non-dispositive vote?
No, ranked choice voting is a better way of identifying the candidate with the most popular support.
Popularly
And
called.
when the state has had better ways of doing things, we've gone and modified the Constitution, as we did for purposes of utilizing voting machines, and as we did with regard to absentee ballots. Why not follow that same process here?
Because there's no constitutional doctrine in Maine that says changes to elections are bad, so the legislature can't do them, right? There's nothing that says, like, we've taken away the authority of the legislature to make any changes.
But
and so
there
everything
is
has to be done
authority
by
that says
constitutional
you
amendment.
can't make changes that are inconsistent with existing provisions.
That's true. And the most votes wins is consistent with the plain language. If the legislature were to amend the Constitution to have that this is a plurality system, right, that it's the most votes wins, then you have that in the Constitution. If the question is, what's the change you'd have to make now to give them that
Before your time
authority?
is up, I just want to ask you, To what degree do we look to the past, look at the historical derivations from this to interpret what vote means and what plurality means? Should we be looking back or just looking at the four corners of the text?
You read the text in the purpose of what it was intended to do. So you read its language, which is important. And that's what I mean by saying plurality is not anti-majority. If you have a system that doesn't lead to a failed election,
But doesn't the winner end up with a majority?
and that would be a good thing constitutionally. So we've shown why that's not true necessarily.
Depends on what you use for the numerator and the denominator in the equation.
Well, remember, there were good reasons to ask to have majority provisions in first, right? We didn't throw that out because we said it was. May I
Finish your sentence.
That we didn't throw out the majority provisions because we said it was bad to have that much popular support. We threw out a trigger that could lead to a failed election, and that's the fix that plurality has, and that is a fix that ranked choice voting has, and that's why it's consistent.
Thank you.
Thank you.
And Attorney Bolton, we're happy to hear your argument.
Madam Chief Justice, and may it please the court. I'd like to start with, I think, the question of why it is that when the first round of tabulation and ranked choice voting is complete, that constitutes the plurality that's required by the Maine Constitution, because I think that's ultimately the key issue in this case, and there's 4 reasons. The first is the inherent nature of ranked choice voting. Ranked choice voting inherently proceeds in sequential rounds. If it didn't proceed to be tabulated in sequential rounds, it would be something other than ranked choice voting. It's an inherent characteristic of this method of tabulation. And LD 1666 would not change that. So when the voters decide their first best choice, who they want to hold the office, their first choice for who they want to hold a particular office, that choice has to be tabulated. It's tabulated on election night, and you have a result. You have a result.
But doesn't the very existence of ranked choice voting change the way in which people may vote? And I mean, part of the purpose of it was to ensure that people could and would perhaps cast a vote for the candidate that they most favor, even while knowing that that candidate essentially has no chance of winning against the other candidates, and then just saying, okay, I know he has no chance, but I wanted you to know that I think this is a good candidate. I mean, isn't that really part of the purpose of ranked choice voting, is to allow additional voices to be heard?
Fair, Your Honor. That is one of the strongest policy arguments in favor of ranked choice voting. I don't dispute that at all. There are policy arguments against ranked choice voting, and I think the point here is we're not here to discuss, although my friends on the other side, I think, would like to, we're not here to discuss the policy merits of ranked choice voting.
But on that point, do you accept the premise that ranked choice voting does a better job at expressing overall popular will than single choice voting does?
Does it express popular? It certainly allows for more information to be gathered about the details of contingent preferences that voters might have.
Does it change voter behavior?
I think it could, certainly. I think there are certainly voters who probably would not vote for a third-party candidate except in ranked choice voting because they know they'll feel that that's sort of throwing their vote away because that candidate has
Is the question of whether or not it's a better system than simple plurality, does that have anything to do with what we're doing here today?
It has nothing, Your Honors, to do with this question, which is solely focused on the question of whether it's consistent with Article 4, Section 1, or Part 1, Section 5, and the other provisions of the Maine Constitution.
In that regard, whose burden is it on this appeal? Who has the heavy burden? Is it you? Or is it the proponents?
Well, Your Honor, I'm not going to disagree that there's a presumption of constitutionality. I think you could find briefs that I filed with this court singing the praises of the presumption of constitutionality. So there is a presumption of constitutionality. What I would say, though, is I think it is highly relevant that the justices have looked at this question in 2017.
But that's not binding on us.
It's not binding,
We're dealing with a different statute.
You're dealing with a different statute that does not change anything about the process of how ranked choice voting works. It just changes the words used to describe the process.
Well, it changes the concept of what is a vote. And I guess one question I have is the Constitution ambiguous about what a vote might be? And if so, why can't the legislature define it by statute?
I think I was actually going to get, this is my number 2 reason why the first
That's
plurality
great.
is the correct plurality, because Article 4, Part 1, Section 5 actually provides, I think, very specific clues, and the Chief Justice's question gets to this, very specific clues as to what the framers understood a vote to be. And it has, that provision requires that the municipal officials be able to quantify in the election return that's completed on election night the number of votes for each candidate and write a number next to each candidate on the election return. That's required by the Constitution. That can only be done if a vote is the first choice vote is the vote.
But then Article 9, Section 12 is the section that the other side is also relying upon, says that the legislature may by law prescribe the manner in which votes shall be received, counted, and the results declared. So can they alter? So that does seem to give the legislature perhaps the authority to alter that.
I think what that provision is intended to do, based on the historical context in which it was enacted, was to give the legislature the ability to set the detailed rules for how towns will be subdivided into election districts.
And that related to how the town gathers and reports the election results?
Correct, and it allowed.
Any other section, or is that just a procedural?
I'm sorry, I didn't hear the first part.
Can we overlay that language on any other sections, or is that just a procedural standalone provision?
No, I think it's a standalone provision, and I think if you want contemporaneous evidence of that, if you look back, the original version of that section was enacted in 1870. And then in 1879, and this was there was an opinion of the justices, which my friends on the other side refer to in one of their briefs, that actually discusses the interplay between an election statute and the provisions of the Maine Constitution regarding sort, count, and declare, doesn't mention this provision at all. So you would think if this was some major expansion of the legislature's ability to legislate in the field of elections where the Constitution has specific procedures, that the justices would have mentioned this in a decision, a very important decision where, you know, one of the biggest decisions, election crises we've ever had in the state of Maine. You think they would have mentioned this provision, they don't.
But it is curious that that provision, Article 9, Section 12, has 2 clauses. The first clause seems to relate directly to what you're addressing, that the legislature may authorize, by law authorize the dividing of towns into voting districts for all state and national elections, period. And then the second clause, and prescribe the manner in which votes shall be received, counted, and the result of the election declared. Why is that second clause necessary, given the provisions in Article 4 and Article 5 regarding how the towns operate?
I think, Your Honor, I would go back to the adage of Justice Scalia about hiding elephants in mouse holes, and that's not what the framers of the Constitution do. And you know, the idea
that's a pretty big mouse hole, I think. Prescribe the manner in which the votes shall be received, counted, and the result of the election declared.
Well, again, in the context of making this very modest change to the Maine Constitution that allows towns to be divided into subdivision, it would almost be sort of a non sequitur to have the second provision, the second sentence of this provision, grant massive new authority to the legislature after it follows a very modest provision.
The word manner might be a clue that it's more procedural. I mean, the legislature couldn't say, you know what, you get 2 preferences because you're white, you're Christian, you're whatever, but you only get 1 preference because you're not. I mean, that's fiddling with the vote, isn't it?
Yeah, as I understand your question, I think I agree, Your Honor. Yeah. Yeah.
Are you going to get to your points 3 and 4?
Yes, points 3 and 4. Thank you. I was. So the other 2 points, just briefly, Your Honors. this concept that the winner is determined based on the first plurality, we now have experience with ranked choice voting. My friends on the other side talk a lot about how you should take into account the experience, the actual practical experience of ranked choice voting. We now have that experience, and we know how this works. That the election returns come in, the election returns say who won the first choice vote on election night. The next day we wake up, we find out who won the first choice vote. And then if it's not by a majority, if it's by less than a majority, because ranked choice voting ultimately requires a majority in the final round, we have a week of
Well, depending on what
tabulation.
the denominator is, when we can go back and forth on that whole argument.
Well,
But
certainly,
wasn't part of the purposes for the constitutional changes that took place back in the 19th century to better reflect the will of the people? And to the extent that that is true, maybe make an analogy. In the context of polling, you can do a surface poll to find out how people voted, or you can do a deep dive poll that goes into specific issues to find out why people voted, and that better expresses their, or at least you have a better sense of what their will was. Why isn't that true of ranked choice voting?
Well, Your Honor, I think, again, that's more of a policy argument about why ranked choice voting.
Oh, it's part of the reason for the constitutional changes, as far as we know, looking at the history, to try to better express the will of the people. If you ask them further questions, you get a better idea of what their intention is, do you not?
I think it's fair to say that the purpose of the constitutional amendments was to avoid failed elections and to avoid this idea that the politicians
Isn't it possible
would
that
pick.
two things could be true at the same time?
Well, of course, Your Honor, it's possible for two things to be true at the same time.
Ranked choice voting doesn't increase the, over here, I know the acoustics are tough. Ranked choice voting doesn't increase the risk of failed elections, so in that sense, it would still be consistent with the purpose as you've just described it, wouldn't it?
I think the issue is that there were different ways. They had a problem in the 19th century. There were different ways that they could have solved that problem. They could have decided they wanted to solve it with ranked choice voting, with a different kind of majority system that doesn't produce failed elections,
Well, that's
which
sort
is
of,
what ranked choice voting is, right?
A little contrary to sort of what was happening historically at the time, right? I think all the parties sort of have agreed that at the time the Constitution was amended, this concept of ranked choice voting wasn't particularly widespread, certainly, if at all, in the framers' imagination. Would you agree with that?
I'm not sure that there's evidence that I think I would agree with that it wasn't
They may have
widespread.
understood
That's
runoff elections, but not
correct.
ranked choice voting.
That's correct, Your Honor. But there are other methods of voting that are specified in our Constitution. I mean, if you look at Article 4, Part 3, Section 18, there actually is a form of runoff election that's specified, and that was enacted a few decades after the change from majority to plurality. But that actually creates a type of runoff election when there's a competing measure and a direct initiative. So the framers knew how to create these other systems of deciding elections, and in this case they chose to enact a plurality system, which is a way of solving the problem, but it's a way in which once you've decided who's got a plurality, who has the most votes, which is done again in the first round, you have your answer. You have the winner. The win condition has been satisfied.
That's assuming that the definition of vote.
Correct.
Right, and I think that's what
right.
we're struggling with. So is your concept of what a vote is really governed by this sort, count, and declare language? Is that really our strongest clue as to what a vote is?
I think that's your strongest textual clue as to what vote means in the context of the Constitution, because again, it is literally impossible for municipal officials to write a number on the election return next to, with a rare exception, next to each candidate's name, unless it's the first choice vote. That's the only thing that makes sense.
Well, isn't there an argument that the will of the people wasn't the point of the change? I mean, we changed from plurality to majority, from majority to plurality, because the argument could be made that you really want the will of the people. You want the majority of the people to be supporting this guy. And we had to change it because, well, it may not be the majority will for this person, but this is the person who has the most votes, and therefore this is the person who should win the election. So there's an argument that it was less important, the will of the people, based on the amendment.
I think that's right, Your Honor. I think, I would assume, and I don't have historical evidence for you, but I would assume that the reason why the framers in 1820 went with a majority requirement is because they felt it was so important that we reach a majority that they were willing to deal with failed elections. And then we had to change course because that was producing chaos. So that's why we shifted. We could have shifted to other systems. Maybe it would have been hard for the framers at the time to think up a ranked choice system, but there were runoff systems, there were other systems we could have chosen. They chose a plurality system, which is distinct from the ranked choice system.
In 2017, we said, the language of the Maine Constitution today is clear. For Maine senators, Maine representatives, and governor alike, an election is won by the candidate that first obtains a plurality of all votes returned. Was that too simplistic? Is it different to have the legislature challenging authority in this matter? Does the 2017 decision really help us here?
I think the 2017 decision is logically sound, and it reaches the correct answer. And again, it's easy to overcomplicate this, I think. But at the end of the day, I'll come back to where I started from, which is that inherently ranked choice voting requires sequential rounds of tabulation. It inherently produces a plurality winner after round one, which is the first choice of the voters of Maine in terms of who they want to hold that office. It's as simple as that, I think, at the end of the day. There are the other historical arguments, there are other arguments, but the question is not as complicated, I think, as the yes proponents make it out to be.
So if I understand what you're saying, the Senate question and the current legislation wants us essentially to answer the question posed by the Alaska Supreme Court in Coalhouse, where they said that we didn't explain why the Constitution requires an election to be called after one round of voting, and that indeed if a vote isn't final, a vote count isn't final after the first round, then a candidate in the first place after the first round is not necessarily the candidate with the greatest number of votes. So that observation would be true. Do you agree? In other words, that if the vote count is not final after the first round, then you can keep going?
I think if you were to accept the notion that a vote can be a series of contingent
So your
preferences.
response, in other words, to the question posed by the Alaska Supreme Court would be, yes, except that under Articles 3, 4, and 5, the vote count must be final at the municipal level on the first round.
That's exactly right, Your Honor, because that under our Constitution, which is different than the Alaska
I haven't looked.
Constitution.
And does the Alaska Constitution have any similar provision?
No,
in
it's
it?
actually striking, Your Honor. I would commend it to you because it's striking how different the Alaska Constitution is. It has some very, very short provisions about how the elections are supposed to work with no procedural requirements at all. And then it actually has a catch-all.
Are we outliers? Your opponents have suggested that this court, based on the 2017 decision, that we're outliers, that the rest of the country is going this way on ranked choice. It's a very popular and prominent result, and we're the only ones standing in opposition.
I would disagree with that assertion, and I think all you need to do is, Your Honor, is look at the table of authorities and all the briefs that have been submitted, and you won't find a lot of cases on either side of this question. This is not a legal issue that has been widely discussed.
And in any event, you would say
decisions.
it turns on the language of each state's unique and individual constitution.
Absolutely. And Madam Chief Justice, the other point I was going to make about the Alaska Constitution is not only does it have these very short, succinct provisions about elections, but it actually has the very delegation of authority to the legislature to enact election procedures and methods of determining the vote that Maine does not have in its Constitution, or at least under our view.
Thank you.
Your Honors.
And Attorney Woodcock, we'd be happy to hear your argument as well.
Thank you, Your Honor. May it please the Court. As I've listened to the arguments thus far, two constitutional questions have come to mind. One is, when is a plurality not a plurality? Not so easy to say. And when is a vote not a vote? Going back to the 2017 opinion, and I might add, that was actually prompted by a question from the Senate. That did not come from the governor. That was a question posed by the Senate to the court about its own authority. And it did work through a very detailed analysis, as the court well knows, of the solemn occasion standards. But the difficulty that we have here, and I think the challenge that the justices in 2017 addressed, is if a candidate has reached a plurality, how do you deny that candidate under the Constitution? It's a victory. So my friends on the opposing side here use as an example the Poliquin-Golden race. Now, had the Poliquin-Golden race been a state race, state rep, state senator, or governor, at the point at which Poliquin had a plurality, how under the Constitution could you have denied him the victory? And that is really what the court said. And these arguments about, well, the Constitution doesn't say first plurality. Why would it? Why does it have to say that? It is plain, and that is what the justices found in 2017. That wording was plain on its face. If you attain a plurality at that point, you have constitutionally won the election. Now, the second question that I think is getting interwoven with this is necessarily that means you are prevailing because you have a plurality of votes. What else would it be? Now, I do think that the argument that that has been teased out, I think, in the course of these proceedings is helpful, that the sort, count, and declare aspect of Section 5 of Article 4, Part 1 do shed light on the meaning of the word vote. But
can I take this back to plurality for a second?
Certainly.
I mean, ranked choice voting does produce a plurality in the end, right?
It may produce a plurality, yes.
They produce a majority.
Majority includes plurality. Plurality doesn't necessarily include majority. Do we all agree on that?
We do agree on that, and there's a and the justices in 2017 understood that full well, and they had a very explicit footnote that addressed that particular point. But notwithstanding that, they were drawn back to the plain language of the Constitution, which is, I think, where we are here. That plurality provision, I mean, could anybody say, had the Golden Poliquin race been a state race, that when Poliquin got a plurality, he did not have a constitutional plurality? How would that happen?
Counsel, doesn't that really assume the answer that the question is, what is a vote? I mean, why is that, in your example, why would we say the vote is final at the point when, they've tabulated the first round and Mr. Poliquin had the plurality? That's what we're trying to get at. So I understand how could he be denied? He has a plurality, but why is it final at that point?
I guess I would say, I think in order to find that that's not controlling, you'd have to find that the marks of favor, perhaps we should call them, are not votes under the Constitution, that they are something other than votes. Because if he had gotten a plurality of votes, then under Section 5, if he were a House candidate, he would win. And that is what I don't see in Section 5, and of course it applies to the Senate and the governorship as well, are degrees of plurality. And there is an argument on the other side that, well, because you don't see degrees of plurality, that means they're there. But that doesn't really jibe with the text of the Constitution.
Earlier, you were going on to your second point of when is a vote not a vote, and you said that that the other provisions, the other language in Article 4, Part 1, Section 5, sheds light on the meaning of vote. So could you just go back and address that point?
Sure. What is remarkable about the Maine Constitution, and I think it is, I think in this respect perhaps we are an outlier, but I would say it's a posture in which we should take pride. Section 5 provides for a very detailed, open, transparent process by which the public is made aware in a way that builds public confidence in the results of votes. And you see that in the sort, count, and declare formula, and you also see it in the requirement that the results of the votes be attested to. So there is accountability built into that process. I don't know, obviously, the constitutions of other states, but at one point I did look into it, and I was surprised at how detailed Maine's was. And to me, the values that are being served there, and of course, as you construe the Constitution, you try to give life to the purposes of it, were to build public confidence in the process, and keeping in mind that all those provisions were in the original Constitution. So the plurality standard, when it finally was engrafted over time, was engrafted onto that pre-existing process that Maine voters required, I would say, as the fundamental law to maintain confidence in their electoral system. And I would say that it worked. That if, anybody who has attended any of these situations where you're seeing the vote counting going on, it is a confidence building process because it is open and transparent. You are capable of seeing what is happening. You do have people who are accountable for what they do, and they are at the local level. So I think those are all values, that transparency, reliability, accountability, and clarity. And I would add on the last point, the point of clarity. That is certainly one of the objectives that the amendments to the Constitution over time in the House, Senate, and gubernatorial races were trying to establish, and that is a clear and readily ascertainable result.
Well, you're singing the virtues of the process, why it's a good process, but as we asked and established earlier, we're not in any way determining which method is better or which is the good one. It's whether or not it is mandated by the Constitution.
But that really is the point I am trying to make, that I'm certainly not here to argue the merits of ranked choice voting over any other part of it. What I'm really trying to argue is, because it was argued, of course, in the briefs, that because the purpose of the plurality amendments to the Constitution was to, express the will of the people or end the failed elections or whatever, that ranked choice voting is consistent with that. What I'm suggesting, all the terms I'm talking about are based in the Constitution. And so the purposes that I'm reviewing here, I think are constitutional imperatives. And as the court looks at liberal construction of the purposes of the Constitution, I would say, looking overall at Section 5, which is really the comprehensive provision here, the purposes should include that those provisions, the sort, count, and declare provisions, as well as the attestation provision, coupled with plurality, provide for clarity and accountability and reliability and transparency. And all of those values should be liberally construed in interpreting that provision. And I do think it is important that as a historical factor, and I think the Durham case really spells this out with some detail, that at the time these plurality amendments were added to the Constitution, ranked choice voting was not a system that was known. So it wasn't as though they were picking among different competing systems. I do think that there is an effort on the part of LD 1666 with its definition of single choice voting to kind of suggest, and maybe overtly suggest, that, oh, it's just a bunch of systems. And so this first past the post system, which the court characterized back in 2017, the plurality system is giving us, that's just another system. I would say it's the other way around. The plurality system, or the plurality standard came first, and the descriptions of it came later. And so these are not competing systems. It was a constitutional system that was a substitute for the majority, where once the candidate with a plurality was ascertained, constitutionally, the race was over. I think that is where we are. And I would commend the court. The 2017 opinion is really quite remarkable in my view, and I've gone back and revisited it a good deal now. But it is a tightly written decision. It is succinct. It is not true, as the Alaska Supreme Court said, that the court didn't explain itself. It is not true, as the Alaska Supreme Court said, they didn't cite into constitutional text. Looking at the footnotes in that opinion, in particular the citation to the Rockefeller versus Matthews case and the Indiana Attorney General versus Anderson case, the latter in particular, which was an 1887 case, there is a very detailed discussion in there about plurality and citations into then current political and legal treatises on elections. And that was clearly a deliberate effort on the part of the court to engraft into this very succinct but lucid opinion.
Can I ask you in the time you have remaining?
Sure.
I think both parties referenced the fact that probably back in 1880, the concept of ranked choice voting was not in anyone's mind at the time. So as we look at our Constitution, should we be originalists and say if they weren't thinking it back at the time, that it cannot happen in the future? Or should we say that constitutions are broad statements of principle that evolve as society evolves? I'm asking you, to what degree should we consider the fact that no one was thinking RCV back then?
Well, I didn't mean to interrupt, Your Honor. I think you look at the plain text still, and I think any way you look at it, whether you look at it under a present-day lens or back then, and I do think what people understood back then mattered because it was the people back then who ratified the Constitution. And there's a good deal of impatience, I would say, expressed with the Constitution on the other side of this question. The Constitution is hard to amend. It does express the fundamental law. The reason it's hard to amend is it protects the rights of minority interests. And until ranked choice voting, the thought was we should have a broad consensus for our electoral system.
Thank you.
Thank you.
And Attorney Brann, I understand you reserve 3 minutes for rebuttal. Can I go to the language? I'm still struggling, I guess, with the language that is in Article 4, Part 1, Section 5, and then essentially duplicated for state senator and for governor. And it seems to me that it's not just sort, count, and declare. It goes further. It really, if you summarize it in sort of plain language, it seems to say the municipality prepares a list of the persons voted for, that's the sort, count, and declare, and that they prepare that list, and that the list is then transmitted to the governor, to the Secretary of State, and in some instances the governor, and it is the governor or Secretary of State who shall examine such lists and declare a winner as the person appearing from that list to have been received a plurality. And I'm struggling to see how we get out of that. And I'll say, well, they prepare a list, but the Secretary of State gets to do a whole bunch more things and declare somebody else to be a winner.
I think the short answer, Your Honor, is that we obviously we think this is the tail wagging the dog. But I mean, what the problem is in this regard is that there's the specific things there which were not part of the original briefing. It doesn't appear at all in the RNC brief, for example, at all. And a number of these things I have to report are.
And we're supposed to ignore them if we think that they are determinative?
Here's the difficulty in the concept in the conception of an opinion of the justices. We look to what's before us, and everyone briefed carefully the plurality issue, and that's obviously what we came to.
Well, isn't what's before us the question that we received?
Fair enough.
From the Senate?
And so, for example, one of the requirements, which was alluded to by Mr. Woodcock, and which I think you just referred to as well, says that the copies of the lists of the voters shall be attested by the municipal officers, not done anywhere in the state of Maine. Okay, so if the concern is, oh well, we can't have ranked choice voting because some portion of it we don't think that's being done. Well, there are a lot of other things and a lot of collateral consequences.
That may be the question that's not before us, whether the municipalities are performing their obligations.
But if the argument, I guess I'm maybe try it differently. The argument, our position is that if you're trying to determine the broad issue, does this provide a plurality winner? You know, which as Justice Meade said, yes, it does. Or Justice Lawrence said, hey, if you ask more questions, you get better answers. I think both, you put those two together, plus the presumption, which we now, I think everyone agrees on, the presumption of constitutionality, we can say yes. If there are other types of ways in which someone might want to attack ranked choice voting beyond just the broad issue of plurality, that's the hill that we have to take that hill. But once you get beyond that, if we want to look at it, we should do it in the context of an actual litigated case, as opposed to a couple of pages at the end of an argument that's mostly about the broader issue of plurality, which we've obviously been debating at great lengths today.
Thank you, counsel.
Thank you.
Thank you, counsel, and all of the people and parties who filed briefs in this matter. We are cognizant of the pending end of the session, and will, however, need to take this under advisement, and will issue something in due course. With that, we will be in recess this afternoon.
All rise. All persons having anything further to do with the Honorable Justices of the Supreme Court may mark their attendance here to call the Chief Justice, and this court now stands adjourned. God save the state of Maine and this honorable court.